Good morning, everybody. Thank you for joining us for the December Enterprise Risk Management Toolbox webinar. A couple of housekeeping notes before we get started. If you've dialed in by phone but haven't logged in by computer and you want to see the slides that will be shown, please point your web browser to readytalk.com. In the box where it says Participant Join a Meeting, just enter the same access code that you used for the call, 9879821. Then on the next screen, just scroll down, enter your contact information, and click OK, and you will be put in the webinar. Please stay aware of the level of background noise in your area, and if it becomes too noisy, please put your phone on mute. If your phone doesn't have a mute button, you can use the ReadyTalk controls, which are *6 to mute and *7 to unmute. Please do not put your phone on hold during the call. If you're called away, you can just hang up and dial back in, and that won't disrupt the call. But if you put your phone on hold, it will transmit your hold music to everybody else. I'll be keeping an eye on the phone lines, and I can individually mute lines, but it's a lot easier if people just stay on top of things. And let's see, with that, as I said, we're leaving the phone lines open. If you have any questions, feel free to ask them as they come up. You can also type them in the chat box, which I will be keeping an eye on, and we'll relay to our presenter at appropriate moments. Given that, let me introduce our presenter today, Norman Hamill. Norm began serving in the University of California Office of General Counsel in 2006, where he works on risk management-related litigation, particularly in the general liability area, and also provides counsel to risk management staff on insurance and related issues. Before joining OGC, Norm worked at CNA Insurance in San Francisco, where he was in-house coverage counsel. And before joining CNA, he worked at Coley Godward LLP in Palo Alto, and as an associate and then partner at Gordon & Reese, where his work included representing the university. He has a BA from UC Berkeley and received his law degree from Loyola Law School. Norm, let me hand it over to you.
All right, thanks, Emily. Welcome, everybody. I'm looking at the participant list, and I see some familiar names on there. But why don't we go ahead and get started? Let's see, and so I've titled this the Ostrich defense. But I would like to clarify that this is actually not a defense that I would like to present when I represent the university or when I was in private practice representing one of my other clients. So what is the ostrich defense, right? Everyone knows this visual. It's the ostrich putting their head in the sand and ignoring the danger that lurks nearby. And so it's not just ostriches that do this, it's also people. So, it's human nature that at times there are issues surrounding job performance, right, in terms of we're trying to achieve an objective here, and there are risks that detract or confuse the conversation about how to achieve the objective. And I also call this the Sergeant Schultz defense. Now, unfortunately on ReadyTalk, I don't have this great 30-second video that I had when I presented at the Risk Summit, but for those of you old enough to remember Hogan's Heroes, Sergeant Schultz would say, "I know nothing, I saw nothing," when he was in the prisoner of war side of the camp. And that's something that I actually am encouraging everyone not to fall into. And today's presentation is going to attempt to demonstrate why we don't want to have to go into court with the ostrich defense. I'm going to run you through some of the legal framework for liability, and I'm also going to talk about a case study using the GM recall and the ignition switch there. It's a fairly extreme case study, but we'll review that, and I think reviewing that in the context of what we'll go through will help you see why it's important to do the right thing, identify risks, try and address those risks, even if they can't be eliminated, they can be mitigated. So here in Understanding Risk, these are various questions that I get frequently when raising risks and suggesting ways to deal with them. Right? We don't have the resources, so why do it? Even if they're available, they're insufficient to completely fix it. We're creating a roadmap for liability, and the risk isn't my problem. And I'm going to walk you through and hopefully demonstrate why these are there are better answers or better ways to frame these questions. And this presentation actually originated out of the third bullet point here on this slide. And I was presenting as part of a OPRS group presentation to an outside agency that was evaluating and rating the university's enterprise risk management program. And I was talking about what OGC was doing and how really the work of lawyers is essentially ERM. And I got a question from one of the raters who was actually a professor at, I think, North Carolina State at the time. And he wanted to know how to respond to this question when you get CEOs or other senior leaders that say, hey, aren't we just creating a roadmap of liability if we evaluate and prioritize our risks, right? Everyone's, I think, has seen the heat maps surrounding ERM. And my short answer was, well, no, I would rather know what they are, right? Because if we can then deal with the ones that are the most significant risk, and you're actually doing the right thing, you're reducing the overall risk to the organization, and you may have risks that end up in liability, but at least you were doing something. You were trying to explain, well, look, we've evaluated our top 15 risks, and we took $10 million, and we dealt with the top 5 of those risks. And this year we're going to do those risks. Now, that may end up in liability because you didn't mitigate the risk in time to avoid that event, but you have a basis to explain your decisions and your reasoning and why you are where you are. So with that, let's move on to the next slide here. And I'm going to come at this from the framework of a plaintiff's attorney because that's my world that I live in, right? I get cases when the underlying event has happened. And to borrow a line from our former Chief Risk Officer, Grace Cricket, litigation is really failure management. Even if doesn't create liability, you've created operational impact on the organization in time away from doing the core mission while you're supporting the litigation. You're spending money to defend the litigation. So I come at it from the framework of, all right, how is this going to be pitched to a jury? And if I'm a plaintiff's attorney, the first place I look is not only, as a plaintiff's lawyer, you know what the law is, but you're also going to look at that organization. You're going to look internally into that organization and see what standards the organization has established for itself. And so here you see the statement of ethical values, and I've excerpted the statement, so it's not everything that's in there. But if I'm going to go back really quick, if we go through, if we think about these questions here, right? Now let's keep those in mind as we move into the statement of ethical values. These provide some level of guidance as to how to frame those questions or even how to answer them, right? So we're committed to the highest ethical standards in furtherance of our mission. We recognize that we hold the university in trust for the people of the state. Our policies, procedures, and standards provide guidance for application of the ethical values stated below in our daily life and work as members of this community. We will conduct ourselves with integrity in our dealings with and on behalf of the university. We'll be accountable as individuals for our ethical conduct for compliance with applicable laws, policies, and directives. We're expected to exercise responsibility appropriate to their position and delegated authorities. We're responsible to each other, the university, our stakeholders, both for our actions and our decisions not to act. Right? University business is conducted in conformance with legal requirements. So all of these can be very powerful statements in front of a jury when we're dealing with some event over which we have been sued. It could be the pepper spray incident at Davis comes to mind from a couple years ago, but there's also any number of them, whether it's that high profile or it might be a say, a significant car accident involving university personnel. But when I go into court, right, we want to avoid making jurors angry. And that is the quickest way to turn a case into a really bad outcome and a verdict that is, or even a settlement that is much higher than it ordinarily should cost to extract ourselves from a case, is when there are a bunch of facts that make people angry. That would make your neighbors angry. That would make you angry if you were on the other, if you weren't actually an employee of the university. And one thing I say is, if everyone watches the news, if you think about what makes you angry when you're watching the news, it's pretty safe bet that that makes a lot of other people angry as well. And so those are the kinds of things, when an institution is doing X, Y, or Z, you think back to Enron was one. It was a very vilified corporation. ExxonMobil is another one as a result of the Gulf Horizon oil spill. Those are the kinds to think about, and that's the filter that we apply when we're looking at litigation. We want to avoid making folks angry, and when there is conduct that is inconsistent with the statement of ethical values, now you have a plaintiff's attorney who's able to start to build the case to generate outrage and anger at the institution. But in order to get to a verdict, you have to understand what the legal framework is, and essentially at its core, it's reasonableness. But the starting point for liability for the university is the concept of sovereign immunity, right? This goes way back, for anyone who remembers their history, is that the sovereign or the king can't be sued. The king has created the courts and the court system and the framework for establishing liability between subjects of the kingdom. But those courts which the king has created cannot impose discipline or liability on the sovereign himself or herself, as the case may be. So that over the years has been modified over time, and we have a version of it here in the United States, both federally and in California. And that is the regents, which is a public entity, cannot be liable under common law as a private person is. Instead, there has to be a violation of a mandatory duty imposed by law. And those statutes that say you, the public entity, are liable for X, Y, or Z, that is essentially a rollback of sovereign immunity. So on this slide, if we look at direct liability is opposed against the regents only if there's a mandatory duty imposed by statute. A common one here that we have is Government Code 835. Liability for injury caused by a dangerous condition of public property. There is a 2-inch gap in our sidewalk, or there is, whether that is horizontally or vertically. Someone trips over it and falls. Perhaps there is people have created essentially a path off of over a lawn to cut through and make their path shorter and more efficient, but there is a retaining wall or something that is obscured from view, and people trip over that. That can be considered a dangerous condition. Failing to adequately light a parking garage when you know there's nearby criminal activity, another potential dangerous condition of public property. So that's direct liability against the regents. However, there can be vicarious liability for the negligent acts or omissions of its employees. And there's actually a little wrinkle here. The employees are liable to the same extent as a private person, so they can use the common law standards, but just make sure not to cause any undue anxiety. The regents are obligated to defend and indemnify their employees for conduct in the course and scope of their employment. There are certain conduct standards that may cause a loss of that defense, but those are pretty bad. You have to engage in actual fraud, actual malice, and corruption. So generally when you're doing your job, or even not doing it well, perhaps employees are entitled to defense. But the standard is, did the employee act as a reasonably prudent person under the same or similar circumstances, right? In other words, how would you expect your neighbor to act, or how would you expect to be treated if you were in that same situation? That's essentially the standard that is a negligence standard. So we have two important defenses in a dangerous condition circumstance. Did we act reasonably in light of the circumstances, including available resources? Right? So the action or inaction of the entity shall be determined by weighing the probability and gravity of potential injury to persons and property foreseeably exposed to the risk against the practicability and cost of protecting against the risk. So if we think about one of those early questions, well, we don't have enough resources to eliminate this, so why should we do anything? Or we don't have any resources at all. And this is an example of the law providing a basis to understand and respond to those questions. Is no, you can choose not to do something, but you have to demonstrate why what you did was reasonable. Right? So if you have a problem that is a billion-dollar problem, right, and say the state has been reducing its funding over time, you don't just throw up your hands and say, well, we're not going to even try and tackle this billion-dollar problem. Right? Maybe at each campus allots $1 million or $100,000 or $5 million and starts dealing with the most egregious pieces of that problem at each campus. So that's a way that you start tackling that, and then you have a basis to say, well, no, here's why we did what we did and how we spent our money and why we were reasonable. Secondly, there's discretionary immunity. No liability if the act or omission was the result of the exercise of discretion vested in the employee. And so this is a very important one where this truly is, hey, I've got to make a judgment call here on what to do and how to proceed. And what this is saying is we're not going to let jurors, right, average people off the street, second guess the determinations of our public employees, our public officials. All right. Questions so far?
I have a question, Norman. It's Katie Pickard. Students that may be taking courses and as a part of that are required to do internships, which then is an extension of their schooling within the university. What obligation or how does this law apply to them?
Sure. So with students, right, we agree to provide them an education in exchange for payment of tuition and fees. There is nothing in the law that says we are responsible for the acts or omissions of the students. Right? We are not vicariously liable for what they do in the same way that an employee, in the same way that we're vicariously liable for an employee acting in the scope of their employment. And so when they go off to these other institutions or locations, whether it's a student nurse going to Kaiser to do a rotation, or a education undergraduate doing an internship in a K-12 school district, there's nothing in the law that says we're responsible for their acts or omissions. Generally, those folks, the students who go to the host institutions are going to have the vicarious liability, if you will. But then what happens when you're negotiating the agreements as to who takes the liability for the student's potential negligence, you'll have discussions over who's required to carry the insurance, who's required to provide the indemnification. And our standing orders actually do allow us to indemnify on behalf of students. And so that gets, generally the hosts take that, but sometimes they push back, and Nicole and I frequently will help negotiate those contracts so that they're acceptable to both sides and enable the students to go and experience the educational opportunity.
Okay, so in other words, you are allowed to indemnify, say, Kaiser for a nurse that may be doing an internship there.
For one of our students.
Via contract for one of the students.
Correct, but the law as a matter of course doesn't make us vicariously liable for them.
Correct. That is a very good explanation. I totally understand the difference.
Okay, great. So, as I've gone through and talked about the statement of ethical values and the legal framework, I've sort of reframed the questions. So should we take steps to investigate, evaluate, and prioritize the risk, or should we take limited or no action? Which choice better meets our ethical obligations and is consistent with the legal framework? Which choice better supports reducing, managing, eliminating the risk when resources are available? Now, granted, the way I framed the questions on the front end and on the back end, I think beg the answers, and with my viewpoint, with litigation as my reality. But hopefully this helps you understand kind of where I'm going and why that's important if you're thinking about, well, how would I be judged, or how would my colleagues be judged if we didn't tackle X or didn't tackle Y? Or if I were a juror and I were being asked to judge the conduct of an institution and its employees. So let's go to the GM case study, which is a very extreme one, but I think it's very instructive. So an ignition switch used originally thought in 6 models, it's since been expanded, failed to keep the cars powered on in all circumstances. And there were about 2.6 million vehicles subject to this recall, and earlier this year 2 million remained unrepaired. I don't have updated numbers on that at this point. But what was happening is the ignition switch was on the side of the steering wheel stalk. And when you turn it from off to accessory, right, that turns on your lights and turns on your radio even though the engine is not up and running. You're just pulling electrical power. And then when you turn it on to run, that turns the engine over, starts the engine, off you go. Well, what was the problem is that people's knees could hit that ignition switch and move it out of the run mode and into accessory mode. And so we'll get to why that's such a bad thing. So GM identified 54 frontal impact crashes involving more than a dozen deaths. GM finally came out and they said that they believe that 13 deaths were related to this problem. And I'll get to some statistics, but that number, it looks like it's much, much too low. 15 employees were fired for inappropriate conduct. GM went out and commissioned the Valukas report. Anton Valukas is an attorney with a Chicago law firm. He was hired to investigate the circumstances. He issued a report, and GM released it to the public. Congressional committees and the DOJ have investigated. The National Highway Transportation Safety Administration administered a $35 million fine, the maximum available for failing to timely report the problems. And GM created a compensation fund to pay victims of car accidents where the proximate cause was the failure of this ignition switch. And so let's look at the GM statement of ethical conduct, right? At GM, corporate responsibility is more than words. It is an acknowledgement that our actions shape our reputation. Doing the right thing remains at the core of ethical business conduct, but is no longer enough, right? And so as you read through these, you see that these kind of look like principles that are embodied in the university's Statement of Ethical Value. The words are a little bit different. And if you go around, you look at various Statement of Ethical Values of other institutions of higher ed and Fortune 500 companies, they all have something that to some degree embodies a core set of principles. Right? And these are supposed to be the standards by which the employees perform their jobs, and GM is evaluated. So let's move on to what the Valukas report said, and keeping in mind those Statement of Ethical Values. An engineer chose a switch that was so far below GM's own specifications that it failed to keep the car powered on. So there were actual torque requirements set for this ignition switch, and the engineer approved this switch even though he knew it didn't meet those specifications, and he didn't raise the issue above him in his chain of command to get approval to do so. And so engineers did not understand that when the car stalled, airbags would not deploy. So here's the thing. So the people's knees would bump the ignition switch, turning it into accessory mode. So the air conditioning would still run, the stereo would still be on, your lights might still be on, but you lost, the engine would turn off, and you wouldn't be able to accelerate or control the car by the gas pedal in the engine. What they didn't understand is that they would also lose the power steering, power brakes, and the airbags. And so engineers, what they thought, this was a convenience issue, not a safety issue, because, okay, well, you have a rolling stall, but when you have a rolling stall, you're still able to fully control the car. You can steer it, you can brake, and you can do all of this other stuff. But they didn't appreciate that they were losing significant control mechanisms, or part of those control mechanisms in the steering and the brakes when that happened. Moreover, when there was an accident, you lost a critical safety mechanism in the form of airbags. They didn't understand that. And they didn't understand the circumstances because they were perceived to be rare. They assumed that the ignition switch was operating as intended. The Valukas report said that there was no demonstrated sense of urgency right to the very end. And at the recall was issued in January of this year, I believe, and in December of 2013, the recall committee had met, and they deferred their decision to gather more information. And even at that time, back in December of 2013, the people presenting to the committee still didn't understand that these fatalities were related to this problem, and failed to notify the committee of these fatalities. So looking at this, it turns out that this problem had been identifiable but unaddressed for 11 years. Numerous groups and committees within GM had looked at this but failed to take action, or just didn't have a sense of urgency. This next bullet, the GM nod, this is a cultural thing where everyone nods in agreement to a proposed plan of action, then leaves the room and does nothing. Right? We can all understand how those kinds of cultural things can build up within an institution. And ultimately, I've talked a little bit about here that he approved the switch because he believed the switch had performed properly in tests, even though that the torque was not as specified. In 2007, a state trooper and a university non-UC researcher identified the problem. They're the ones who figured it out, external to GM, not internal to GM. This information was provided to GM. They were notified of it, and they dismissed it. They did not. It took them 7 years to come around to say, "Oh, you're right. That's the problem." Outside counsel, when defending these lawsuits, right, they warned that the failure to address the problem could lead to assessment of punitive damages. In essence, the outside counsel is saying, hey folks, You have failed to address this. You have engaged in the Ostrich defense, the Sergeant Schultz defense, and it has gotten so bad for so long that you're now going to be punished for this. Not only are damages going to be awarded because of the damage you caused to the individuals, but you're at risk of having a jury award damages simply for the sole purpose of punishing you. That's in essence what punitive damages are. And again, personnel failed to raise it to key decision makers, and lawyers and engineers within the company also failed to elevate this issue. So this is, and I put that bullet in here, even though I as a lawyer am providing the providing this seminar or giving the talk today, it's something that I keep in mind in my practice as well. What is the right thing to do, right? Can I really just walk away from a problem that has come across my desk? How do I elevate that? Who do I get that to? All right. Ultimately, there were some recommendations that there was more of an emphasis on safety, assigning individual accountability, improving communication between and within groups. And again, they thought it was very significant that GM wasn't able to figure this problem out, even though they'd known about it for so long.
Norm, I have a question.
Sure.
Where does that the punitive damages? They were charged punitive damages in this case.
No. And I'm gonna get to that here in a minute. These were lawsuits that were going on around the country when there was an accident. There was a stall, a rolling stall, and there were differences in opinion on causation. Was it due to driver error, or was it something with the car? And the lawyers in those cases, and I don't remember, one of the national counsels was King and Spalding out of Atlanta, but they were saying, look, these cases have been going on for so long, we can't demonstrate, we don't have anything internally to show that this was not a problem affirmatively and why it wasn't our fault, that they were saying from the liability perspective, we likely have liability and you're risking punitives. I did not attempt to go through and find out what those results were. But what GM did, and I mentioned earlier and I'll talk a little bit more about it now, they created a compensation fund for these victims. Remember they said there were 13 deaths? So the claim facility, the claims resolution facility they established, has no cap on any compensation to certain individuals. There are 3 categories. Those who can demonstrate that someone died as a result. Category 1 are really significant physical injuries, quadriplegia, paraplegia, amputations, brain damage, pervasive burns. Man. And Category 2 is physical injuries that required hospitalization within 2 days of the accident. And so they said there were 13 deaths. So far, there have been 229 death claims submitted. 36 have been determined to be eligible, which means they will be compensated. That's 3 times, almost 3 times the original estimate. They've only declared 33 ineligible so far. 74 need more documentation, and 35 are under review. And 51 were submitted with no documentation. So that's just the death claims. 142 Category 1 claims were submitted, and 1,844 Category 2 claims were submitted. And all told so far, 80 claims have been determined to be eligible, and only 216 ineligible. The rest either need more documentation or under review. So, and I looked for statistics to see how much has been paid out. It's not available yet. I'm sure they will at some point make those numbers public. But it's going to be a very, very, very expensive mistake. And so, again, I come back to application, action or inaction, and ethics. Integrity, excellence, accountability, exercising responsibility. People are responsible for their actions and their decisions not to act, and conform with legal requirements. Now, I know GM is an extreme example, and we hope that our university colleagues will all act appropriately. right? But this seminar is an attempt to encourage folks to say, wait, no, we do want to do the right thing. If we do have litigation or we do have a liability creating event, we will take our lumps, right? You'll turn it over to the lawyers, engage the failure managers, but we really want to get to the root cause of these problems. And if we see problems before an event, let's not wait. Let's try and address those as we come across them. So again, action or inaction and legal framework. Reasonableness standard. What's reasonable, right? What would our neighbors expect the university to do, right? Doing nothing is not a defense. If you go in and you say, well, I didn't bother, I didn't have the resources, that doesn't get us anywhere. And not to be too simplistic, but if you look at many of you, I'm sure, are parents, and you have kids. I told you to brush your teeth. Why didn't you brush your teeth? I don't know. Didn't want to do it, right? Those are the kinds of things when people are angry when they feel that the university should have known better and should have done something and didn't do that. Lack of resources can be a defense. We all know we're challenged, particularly in the last 5-6 years, but we have to make the case as to why we're going to spend money on some things and not others. And that's okay. We make those choices all the time. And if you act reasonably, you will not be negligent. So do's and don'ts. Do your part. Do what you can. Do your best with what you have. Don't ignore risk. Don't let legal risk prevent progress. Don't be afraid to call risk services or OGC. And that is my presentation. Questions? Silence.
That was outstanding, Norman.
Great, thank you.
Thanks very much, Norm. If anybody does find that they have questions coming up later, you can email them either to Norm or email me and I'll relay them. With that, I will thank you for joining us and say that we hope to see you for the ERM Toolbox webinars in 2015. The first one will be held on the 4th Tuesday in January, which is January 27th. Have a happy holiday season, everybody.
Thank you.
Thank you.
Thank you. Bye.
Bye.